Good morning. This is the time set for case D19C. We can have counsel make your appearance, please.
Morning, Your Honor. Richard Schonfeld, bar number 6815 from Chaz Office, Schonfeld, appearing on behalf of the plaintiff. She is present.
All right, and Mr. you there on blue jeans?
Good morning, Your Honor. The defendant and proper persons present by blue jeans.
All right, we're here on the plaintiff's motion to dismiss the counterclaim with prejudice. I've read everything, so I'm going to give you as a brief time to argue if there's anything new to argue or point out. So that starts with you, Mr. Schonfeld.
Thank you, Your Honor. I'll keep it brief, but in reality, the court gave leave to file a counterclaim related to potential breach of contract causes of action, with us reserving rights to pursue this motion to dismiss. The court did not grant leave to pursue causes of action for fraud, intentional infliction of emotional distress, palimony, or any other tort claims that Mr. asserted. And it is crystal clear that those tort claims are time barred under the statute of limitation, which are 2 years for everything except for the fraud, which is 3 years, and there's clearly no specificity under Rule 9C to pursue a fraud claim. So I'm going to focus on the contract claim because that's what the court allowed leave to amend. And the only manner in which any of these claims can survive as a result of a breach of contract is if they relate back to the original counterclaim. When we look at the original counterclaim, it expressly states that it was a counterclaim for custody. And within that counterclaim is also an express acknowledgement that it was not a complaint for breach of contract. And what I mean by that is it expressly stated that the defendant was desirous of having the repayment of alleged loans be part of the resolution of this matter without the necessity of filing a separate legal action and contract. It expressly says that. So it's an acknowledgement that the complaint, the counterclaim, was not a complaint for breach of contract. And that becomes evident with a hypothetical that I could give. We're entitled to a jury trial on contract claims in family court. If I had done a jury demand as a result of that counterclaim, the court most likely would have stricken it because there was no breach of contract claim. And so when we look in my reply brief at all of the case law that talks about the relation back doctrine, it's clear that you have to be put on notice of the nature and the factual allegations of the claim in order for it to relate back. So there's absolutely nothing in here regarding any express loan, amounts of the loan, dates of the loan, how the loan was incurred, why you're entitled to repayment. Zero, nothing in the counterclaim at all. Even if the new complaint related back in terms of the breach of contract, there are still 90% or so of the claims that are time barred, because the counterclaim was filed on December 31st, 2019. Breach of oral contract is a 4-year statute. So that would mean anything that postdates December 31st of 2015 would be time barred. And when we look at the counterclaim that's been filed, almost every one of the claims is time barred, with the exception of, I believe there were 2 that I outlined in the reply brief. And then the problem becomes whether or not it meets the jurisdictional threshold, the $15,000 amount. And we just don't have enough specificity because we have allegations, for example, that say between 2014 and 2016, the defendant loaned the plaintiff X amount of money. Well, which part of that postdates December 31st of 2015 in order for it to not be time barred if the court employs the relation back doctrine? We don't know. So if the court is going to allow relation back, we would at a minimum need an amended counterclaim to clarify which aspects of the alleged contracts at issue post-date December 31st of 2015 for purposes of statute of limitations. But I respectfully submit the relation back doctrine can't apply in this case because the original counterclaim is completely devoid of any contractual allegations, and therefore the statute of limitations continue to run. All of the claims in this purported counterclaim are time barred.
All right, Mr. I'll give you 5 minutes.
Okay. I'm sure the court is well aware that this idea that plaintiff was not put on notice of these claims is ridiculous. The court has already determined that this amended complaint could relate back to the filing of the initial claim, and I'm quoting from the hearing on November 7th, 2022, at minute 742, the court said, the counterclaim can relate back to when you filed your original counterclaim. So this idea that the court never granted leave to relate back is completely devoid of merit, and moreover, it's emblematic of the repeated issues of playing games with the orders and not being able to get a a completely honest and factual order to the court. Beyond that, the court is well aware that Nevada is a notice pleading state and that complaints are construed so as to do justice. Even if the contract claim does not survive, the complaint could still survive on issues like promissory estoppel, palimony, community property by analogy, because the fact is that the most recent agreement is in October 2019. And in 2018 and 2019, there were still, plaintiff was still receiving considerations in exchange for acknowledging the loans and promising to pay back the loans, meaning still taking more loans in the amount of $10,000, $20,000, $10,000 again. Then after that, the facts in 2018 and 2019 that are alleged, like I said, plaintiff continued to accept consideration. Then plaintiff wrote to me in writing that she was filing bankruptcy multiple times. This was, and told me that I could come to the table as a claimant just like everyone else in bankruptcy. Okay, that turned out, as far as I know, not to be true. Then later in late 2019, the date I don't know exactly, plaintiff sold the house, the proceeds of which she had promised to pay back. At that point, it was approximately $81,000. And then subsequently absconded with the money and said it was none of my business that she would ever owe me any money or any contract or anything. And that email on October 2019 specifically promises that she would pay me back $5,000 until all the loans and debts were satisfied. Then after that, as plaintiff correctly points out, there is no civil extortion remedy, particularly in Nevada. But then after that, plaintiff continued to threaten to kill me, threaten my life on a weekly basis, threaten my family, told me that we would never see, or we would see this as little as possible if we continued with the complaint, and and then eventually threatened to throw out the embryos if I continued with the monetary counterclaim. So the point is that there are multiple remedies that and causes of action that the court has at its disposal to resolve this. Thank you.
Your Honor, may I briefly just
Sure.
state that we object to the representations that my client has threatened or threatened his family, and I'm concerned that he's doing that for the benefit of this ultimately potentially being posted on YouTube through our Nevada judges. Completely baseless claims. I would also note, going back to the substance of the motion, under NRS 11.390, no acknowledgement or promise shall be sufficient evidence of a new or continuing contract whereby to take the case out of the operation of the statute of limitations unless the same be contained in some writing signed by the party. So the singular allegation that Mr. raised in his effort to survive this claim from the statute of limitations problem that exists is that in 2018, plaintiff acknowledged she owed defendant money and she intended to pay in. That's paragraph 43. And on or around October of 2019, plaintiff promised to pay defendant $5,000 a month but never paid, paragraph 71. Neither of those are sufficient to meet the requirements of NRS 11.390. Finally, when reviewing a Rule 12b motion, the court is confined to the four corners of the complaint, and none of the allegations raised by Mr. are included within those four corners. Thank you.
I do think that the plaintiff is right, that the best case scenario the defendant has is that there's enough in the original answer and counterclaim filed on December 31st, 2019 to put her on notice of some contract claims. Those are the only thing that could relate back. All of the torts claims, the fraud claims, all of that cannot relate back to the original answer and counterclaim. So then their 2-year and 3-year statute of limitations would apply from the date it was filed on January 31st, 2023. So I have to look at, because this amended counterclaim has 142 paragraphs. I'm gonna take it under submission and issue a written decision to go through it carefully and see if there's any of his claims that would, A, survive statute of limitations dismissal, and or B, if there's some that do survive that, if they meet the $15,000 threshold. So right now I'm going to take that under submission. So I have two things on your case under submission, and we'll issue two separate written orders.
I'd just still like to make one more note for the record, if I could.
Go ahead.
I want to preserve the argument that Nevada recognizes a continuing tort doctrine, actions emanating from the same set of facts. That's all. Thank you.
Thank you all.
Have a good day, Your Honor.
Thank you.